reason we're starting off with the report of the board attorney is the superintendent had asked me to publicly address the Covington School Board to clear up some confusion and misinformation that's being spread in the community as to the board's role in filling the vacancy on the board and the role of the board attorney. First of all, the local Board of Education does not have the legal authority to take action on a board member's resignation. It does not accept a resignation. It does not vote to accept it or to fill the vacancy that's caused by the resignation. Under the Kentucky statutes, acceptance of a resignation may only be made by the officer required to fill the vacancy, which under the Kentucky statute is the Commissioner of Education. The Covington Board of Education did not vote to accept Denise Varney's resignation at the August 9th meeting because the board is not the officer required to fill the vacancy. The Kentucky Commissioner of Education formally accepted Ms. Varney's resignation on August 21st, thus fulfilling the statutory requirements under Kentucky law. Second, there's been a lot of misinformation about the role of the board attorney in the process. I have not advocated for or against any one candidate, nor have I taken any action for or against anyone's candidacy. I represent the Covington Board of Education, and the duty of legal representation extends to this entity and not to any particular interest, individual interest, or group interest. I have a duty to the best of my abilities to ensure that all members of the local Board of Education are serving in a legitimate fashion, not subject to legal challenge, not subject to an ouster lawsuit. When I first learned that a request had been made by a prospective candidate to file as a sole, unchallenged candidate in the special election and not to run as one of the other candidates in the general board election, I consulted with General Counsel to the Kentucky Department of Education, and I asked about the legal question of whether Ms. Varney's seat was to be filled by appointment, by the Commissioner, or, which is, by the way, what the Commissioner's office had previously told the Superintendent, or whether the law supported a special election instead. General Counsel to the Kentucky Department of Education provided me with what they considered to be the controlling legal precedent that as a matter of law, a vacancy was not legally created until the Commissioner had formally and in writing accepted the resignation. I was advised in the case authorities I was provided, which included Attorney General opinions as well as published cases from the Kentucky Court of Appeals, supported the conclusion that until there was an acceptance by the Commissioner of Education, no legal vacancy existed. I was asked to share that information with the Kenton County Attorney and the Kenton County Clerk, both of whom had also contacted the Kentucky Department of Education in an effort to determine whether Kentucky's school laws and Kentucky's election laws supported calling for a special election under the existing circumstances. This is a technical point of law that may ultimately be decided by the courts. For those who question why I share governing legal authority with other agencies, namely with the Kenton County Attorney and the County Clerk, it should be understood that I merely shared the information conveyed to me by the Department of Education in order to assist with the determination of what was the governing law. I was contacted by Attorney Brandon Volker, who represented a prospective candidate, and as a professional courtesy, and to assist him as he struggled with the same legal question, I voluntarily shared the same information with him. I've known Mr. Volker a long time as a fellow professional. My interactions with him have always been open and in good faith, both in the past and in this matter. And frankly, his public negative comments that have been aimed at me have been disappointing and frankly surprising. Frankly, I would have been remiss in my duty to the board if I had withheld relevant published law that, if not followed, could have undermined the legitimacy of the next Board of Education. Had I remained silent and withheld the legal authorities provided to me by the Department of Education, I would have knowingly subjected a future board member sitting in Denise Varney's seat to possible legal challenge, maybe even ouster. And I would have subjected all other future board members to possible legal challenges as to the legitimacy of their actions taken by the next board. In fact, frankly, it was not long ago when another Covington School Board member, who coincidentally was also represented by Brandon Volker, was elected to the board and then ousted by the Kentucky Attorney General based upon election eligibility issues under Kentucky law. That was a painful, difficult time, both for that individual board member and the school board, which for a long time operated with only 4 members. It has come to my attention that some people have speculated that my actions were in response to criticism by a prospective board member. That speculation is false and is inaccurate. At the time that I initially contacted General Counsel to the Department of Education, it was the early morning of August 15th. I had never met nor spoken to the prospective candidate and was unaware of the personal criticism of myself or my law firm. I did not receive a return call from General Counsel to the Department of Education and did not speak to them until the morning of August 16th. At that time, I was given the case authorities and asked to provide them to the county attorney and to the county clerk. Finally, my duty to protect the legitimacy of the Covington Board of Education's votes extends not only to this board, but to the future board, even if and regardless of whether those votes or actions are to terminate my legal representation of the board. My ethical duty of loyalty lies solely with the Board of Education, both the current one and the future one. The actions which I took were done with the understanding that any of the candidates who file for the upcoming election may be serving on the next Board of Education. And I owe to them, regardless of their feelings about me, the duty to ensure that their votes, their board actions, remain legal and are not subject to being set aside due to a legal question arising from the election. Thank you.